Hello guys, I'm Chirag Akhani and today we are going to discuss the law paper of CA Foundation January 2021. Let's begin with question 1A. So let's read it what it tries to say. First is Mr. S, aged 58 years, was employed in a government department. So fine. The first line it says that there is a person already 58, so that is the actually age of retirement in a government department. He was going to retire after 2 years, still he has to complete his 2 years. Okay, Mr. D made a proposal to Mr. S to apply for voluntary retirement from his post so that Mr. D can be appointed in his place. Okay, now picture is clear. So Mr. S, who is going to be retired after 2 years, Mr. D proposed him that, bro, why are you retiring after 2 years? Rather you take VRS, voluntary retirement service, and please pre-retire from your post. And for that Mr. D offered a sum of rupees 10 lakhs as consideration. He said that okay fine, you pre-retire and I will pay you how much? 10 lakh rupees just because of this. In order to induce him to retire, Mr. S refused at first instance, but when he evaluated the amount offered as consideration is just double of his cumulative remuneration to be received during the tenure of 2 years of employment, he agreed to receive the consideration and accepted the above agreement to receive money to retire from his office. So basically the entire question is about what? Acceptance of the money from Mr. D, and he has decided to retire before 2 years of his retirement. So the question wants to ask is whether above agreement is valid or not. Above agreement is valid or not. So first of all, understand this question is actually from the provisions of Indian Contract Act 1872. But here the doubt is which topic it covers. So according to section 10, we know that if you want to have a contract, a valid contract, there are certain essential elements need to be fulfilled. Essential elements must be present there if you want to have the full-fledged contract. Otherwise contract becomes void or voidable, depends upon the circumstances. So we all know that as per section 23, if we just read about section 23, what section 23 says about? Section 23 says that if object is unlawful or when consideration is something what is forbidden by law, then contract becomes void. Okay, if you want to read the full paragraph of the section 23, it says that the consideration or object of an agreement is lawful unless it is forbidden by law, is of such a nature that if permitted would defeat the provisions of any law, is fraudulent or involves or implies injury to the person or the property of another person, or the court regards it as immoral or opposed to public policy. So section 23 says that if consideration is something, object is something what is immoral or opposed to public policy, then contract becomes void, opposed to public policy. Now in the Contract Act, when we see the lot of examples, there are certain examples which have provided the idea that under what circumstances we can consider certain examples, certain cases as against public policy which are immoral. And one of the topics what is given in the law is trafficking relating to public offices and titles. Look, offering bribe to secure the public offices. Here public offices means the governmental post, the public post where the people are there. For example, if I offer, let's say I will give you 10,000 rupees and you please give me Bharat Ratna. So I'm trying to offer bribe to get that dignity, which is not allowed by law. It is immoral as well as against public policy. So when any person, no matter whether he's existing employee or not, whenever offering any amount to any person to secure that public office, it is immoral, moral, against public policy, and as per section 23 provision, it becomes void. So if you see the entire example, what is happening in the question, the same thing is happening. Okay, you can see here that Mr. D has just offered rupees 10 lakhs to Mr. S to retire early, so that in place of him he can go and take the advantage of that designation. So he's trying to secure the public office, and that's why, guys, as per section 23, that is unlawful object, and I can say unlawful consideration opposed to public policy, and here the contract becomes void. The contract becomes what? It is clearly written that an agreement to pay money to a public servant in order to induce him to retire from his office so that another person may secure the appointment, that is void. So that will be the answer of your first question. Okay, after that, let's do the second question. What it says? Second question says that, okay, ABC Limited was registered as a public company. So, okay, guys, the first hint is given in the question. It is a public company. There were 245 members in the company. Okay, so guys, we can say that here the question may be related to something related to what? Members, the number of members. But number of members constraint come to what? Private limited company. But in the question, it is public company. Let's read further. Are there more hints or not? Their details are as follows. So they have given 245 people's bifurcations. Directors and their relatives 190. Employees 15. Ex-employees shares were allotted when they were employees 20. Others are 20. Okay. Further, they have said that including 10 joint holders holding shares jointly in the name of father and son. So guys, this information is very, very important, but still there is no any concept of private limited. Let's read क्या आगे कुछ वो देते हैं. Further, they say that the board of directors of the company proposed to convert it into a private company. Now, that's the catch. Board of directors of the company propose to convert it into a what? Into a private company. Advise whether reduction in the number of members is necessary for conversion or not. Fine. So this question is basically based on section 2 subsection 68 clause 2. Section 2 subsection 68 clause 2. Basically, section 2 subsection 68 deals with the definition of private company. Private company. In private company, when we speak about members, minimum members must be 2 while maximum is 200. In private company, at any point of time, the number of members cannot go beyond 200. So even in this given question, we have to take care that while making these calculations, whether the number is going beyond 200 or not. If it is going beyond 200, then this company is not allowed to go for private. By anyhow, it has to keep the number below or up to 200. Fine. But while we consider this 200, there are certain exceptions. What are those exceptions? Let's understand. The first is, while calculating the number of members, we will not consider the existing employees. Existing employees will not be considered. Second is ex-employees. Ex-employees means former employees who were the employees and members during their employment and still continue as members, Yeah. Continue as members even after retirement. Even after ceasing employment. Even after end of employment, they are continuous member. That is the one fact. Another fact is that if we speak about joint shareholders or the joint members, let's say there are 20 people or 10 people who are holding the shares jointly, for the calculation purpose they will be considered as one only. So in order to solve this question, we have to keep these three facts in mind, that this 200 doesn't include 200 these employees, even though they are members, but they are not part of 200 ex employees who were the members and they are still continuous members even after retirement. Still they will be excluded from calculation of this 200. So guys, now let's make the solution of this question, that out of the given question, what will be part of 200, what will not be. So guys, directors and the relatives 190 absolutely is undoubtedly they are part of 200, so we will consider this. Then employees, guys, just now I have explained that employees are not part of 200, so they will not be considered. Then ex-employees, here the data is given the shares were allotted when they were employees. So again guys, this 20 will not be part of 200. Now this fact is very important. Others is 20. But do not go directly 20. Please read this fact. It is written that including 10 joint holders holding shares jointly in the name of father and son. That means out of this 20, we have to bifurcate two parts. First 10 and other 10. These 10 are not in joint, but these 10 are in joint name in the name of father and son. It is clearly written that 10 joint holders holding the shares jointly in the name of father and son. So just now I have explained, no matter how much quantity is there, whether there are 10 members, 20, 50, but if they are holding the shares jointly for the purpose of calculation of membership, they will be considered as one only. So out of this 20, membership wise, we will not consider them as full 20, but they will be considered as how much? How many? Only 11. Only 11. So 190 and 11, if you go by this calculation, it comes by what? 201. And just now we have understood that in order to form the private company, maximum number of members cannot go beyond 200. Here one member is more than the specified limit, and that's why students, here public company cannot convert until it maintains the limit of maximum 200. What third question says about? It says that what are the rules which regulate the sale by auction under the Sale of Goods Act 1930? You know what, students always like such questions because no twist, no tricks, directly question is given and straightforward just put the answer. Okay, so over here as well, we do not require to think a lot, directly just write about what is the auction sale and what are the rules. So we studied in the class that there are certain rules about auction sale, like goods sold in the lots. We understood that when goods are getting sold in the multiple lots, then each lot will be considered as the separate contract when the sale gets completed. So we had certain customary methods like saying 1, 2, 3, or just falling of a hammer, or certain combinations of such traditional methods. Then seller may reserve right to bid. Absolutely, a seller has the right to do that. How can they do? We also understood that he can appoint, he can keep certain minimum price below which the sale cannot happen, and if it is happening by mistake, then seller will not be actually liable for that. Then sale not notified, then what happens? What about the reserve price? Just we have understood. Pretended bidding means what? That if seller himself is participating in the auction, then how law will govern those matters. Also we have certain rules regarding knockout agreements, damping, and all those stuff. So we should write all those topics. Okay, so guys, here it was question number 1. Hey guys, let's go to question number 2 now. So what it says, question number 2a, again guys, for the 7 marks and straightforward, it says to define the term acceptance under the Indian Contract Act 1872 and explain the legal rules regarding a valid acceptance. Hey guys, bingo. Here again, there is no twist, nothing like no stories, no cases. Directly just recall the topic and just present it. So what is acceptance and what are the rules? Let's go one by one. So acceptance is explained under section 2 clause B that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. And guys, there are certain rules like you have to elaborate with certain explanation that acceptance must be made by a person to whom the proposal is made. The acceptance must be communicated to the offerer himself. The acceptance must be absolute and unqualified. Acceptance must be made in the mode as prescribed, and some other rules we had understood over there. We had to write them. Next question 2, it says that state the circumstances under which LLP and its partners may face unlimited liability under the LLP Act 2008. So this question is there for the 5 marks. So under what circumstances? Basically, when we discuss about the format of LLP, it says that limited liability is there. Limited liability. The concept is quite clear that even though this partnership is getting dissolved, personal assets of the partners will not be asked to contribute for any deficiency. Limited liability is there. Stake which is there in LLP, only that much will be taken away by the official receiver or the assignee. Personal assets will not be considered, just like the partnership. In the partnership, if the firm doesn't have sufficient assets, then partners may be called upon to contribute more. But still, law says under section 30 that under certain circumstances the partner's liability will be unlimited even though you are in LLP. How? So logic is quite clear. Look, this concept is allowed to be used for genuine purpose, for the honest purpose. But what if you are making this LLP just to make the cheating with the people, to make fraud with the people? Should law allow this? No, not at all. So guys, when you are making fraud with the people, partners who are involved in the fraud, and your intention was not to do any genuine business, but you really intended to cheat the people or the creditors, you wanted to take the loan just by making the fake and a non-genuine entity, then under such fraudulent activities, guys, the partners who know this fraud very well are personally liable even beyond their contribution to LLP. Okay, so how you should have to write this? So look, this is the answer. The liability of the partners and the LLP become unlimited under the following situations: an act done by LLP or any of its partners with the intent to defraud the creditors of the LLP or any other person. Second is an act done by LLP or any of its partners for any fraudulent purpose. But understand, only those partners will be found guilty by the law who know about the fraud, who has the knowledge of the fraud. All those who are unaware about such frauds and such misconduct, those won't be punished by the law. Okay guys, so that was question 2b for the 5 marks. Okay, after that, question 3. Hey guys, another very easy question for the 2 marks. Quite simple. It says that what do you mean by particular partnership under the Indian Partnership Act 1932? Particular partnership. So basically, while we studied, I explained that on the basis of duration, on the basis of nature of business, we can bifurcate the partnership into 2 parts. The first is particular partnership. So that is actually made for one particular venture over, automatically partnership gets dissolved. That concept we understood. We also understood that in such partnership where partners are in the agreement till completion of any undertaking, any venture, and if any one of the partners wants to retire before completion of that venture, how it will happen? They cannot dissolve it, they cannot retire just by mere giving notice to all the partners, but he must have to take the consent of all the partners. Unless they give it, partnership won't get any dissolution. Okay guys, so that's about particular partnership. Okay, in place of that, another question is there, question 3a only. Point 2, who is a nominal partner under the Indian Partnership Act 1932 and what are his liabilities? Good question again, and a simple one as well. While we understand the types of partners, in the first part we have these three, right? Active partner, dormant partner, and nominal partner. So guys, nominal partner, he is the person who just shares his name, but he's not actually interested in the firm, right? And even if you see, his profit sharing will be very negligible. We can even sometimes compare with zero as well. Very, very nominal share he shares. But here question is there any liability? Let's say guys, if all the other partners in the firm have become insolvent, whether nominal partner who just lent his name to the firm to be used, can he be considered liable for all the debts and to the creditors? Then understand guys, answer would be absolutely yes, he is liable to do that, because the people who are interacting with the firm, they know that such person who has given name to the firm is still the partner over there. Okay. Another thing, when such partner retires, he must have to give public notice. So those concepts also we did while doing nominal partner. Okay, very easy question. Fine. Question 3b, what it says that explain business carried on by all or any of them acting for all. Discuss the statement under the Indian Partnership Act 1932 guys. So again, when we read the section 4 of the Indian Partnership Act 1932, it is the definition of partnership. The last line says about this, it is a business carried on by all or by any one of them acting for all. So basically what it tries to say, it simply tries to say that action of one partner will bind all partners subject to certain conditions. So what it tries to say, that all partners are agents as well as they are principals for each other. All the partners are agents as well as principals for each other. So guys, there is not only single directional agency, it is mutual directional agency, and guys, that's why this concept is known as mutual agency. Action of one partner binds the whole firm, all the partners. So guys, if everything is present, sharing of profit is there, business is there, more than two persons are there, but mutual agency is missing, then it's not the partnership. Are you getting my point? And that's why guys, mutual agency is also considered as what? The true test of partnership. True test of partnership. True test of partnership. Okay, so quite easy. Fine. After that, question 3c. Okay, question 3c. So what it says that Mr. B makes a proposal to Mr. S by post to sell his house for rupees 10 lakhs. So guys, some communication is happening. Mr. B is proposing to Mr. S. So it looks that yes, this question is based upon the Indian Contract Act, particularly offer and acceptance. Let's read that what it tries to say. And posted the letter on 10th April 2020. Guys, so this date, let's note it down one by one. The first is 10th April. So this date is the letter of offer is posted. Okay, what says it next? the letter reached to Mr. S on 12th April 2020. Okay, fine. So another date is there. 12th April reached, letter of offer reached. So here there are date of offer first of all. Okay. Then he reads the letter on 13th April. Wonderful question. He reads it on 30th April. So he reads, or rather we can say that comes to the knowledge. This thing, the offer has come to the knowledge of Mr. S as on 30th April. So basically, before we read the question further, let's clarify something. While we solve this question of communication of offer and acceptance, when the offer is assumed as completed. So understand guys that the communication of offer is assumed as completed when the offer comes to the knowledge of offeree. Okay, section 4 is there. We are going to learn about that. Fine. Further, let's read what it says that Mr. S sent his letter of acceptance on 16th April. So guys, here are some dates have been given for acceptance. Another direction. So what it says that 16th April he posted the letter of acceptance. Okay, acceptance letter. Okay. Then the letter reaches to Mr. B on 20th April 2020. Okay. So 20th April, the same letter reaches to offerer with the acceptance. Okay. On 17th April, Mr. S changed his mind and sends a telegram withdrawing his acceptance. Telegram reaches to Mr. B on 19th April 2020. So again there is a twist guys. 19th April 2020, letter of revocation of acceptance reaches. Revocation of acceptance reaches. So guys, let me tell you, if I speak about the acceptance, there are two types of communication. Revocation. Look, once the letter of revocation of acceptance is posted by offeree, already letter of acceptance has been posted, then whether contract is considered as valid or not. So it depends upon which letter comes to the knowledge of offerer first. That is the twist in the question. You can see here कि भाई जो letter post किया था 16th April को, जो पहुंचता है 20th April को, but on 19th, on 6th, okay, what they say, just a second. Yeah, on 17th, I did not write this, yes. On 17th April, just one day after posting the acceptance, Mr. S realized, Arey baap re, I have made the mistake, let me correct it. And he posted the letter of revocation. So bhai, now there is a race between two letters. One is the acceptance letter, second is revocation letter. If revocation reaches first and comes to the knowledge first, no contract, because no acceptance. But by mistake, if letter of acceptance reaches first and that comes to the knowledge first, coming to the knowledge is very important. Then guys, there is a valid acceptance and then Mr. S cannot turn around from the deal. तो ये हमने पढ़ा था communication of offer and acceptance. Okay, if you want to just go through by all those rules, I want all of you to just go by this. It is clearly written here that an offer and its acceptance have no legal effects until it is communicated to the other party. The offer and the acceptance can be communicated by words spoken or written or by conduct. Communication of offer is completed as soon as it comes to the knowledge of the offeree. So you tell me in this entire question, at which date the communication offer shall be considered as completed. So when it is comes to the knowledge, so answer would be 30th April is the date, guys. Okay, sorry, let me put here. 30th April is the date. You can see here. 30th April is the date where we can say that a communication offer is completed. Okay. A communication of acceptance is complete at the different times for the offerer and the offeree. For the offerer, the communication of acceptance is complete when it is put in a course of transmission to him. That means after that, offerer cannot withdraw his offer. We know that very well. Thus, the offerer becomes bound by the acceptance as soon as letter of acceptance is posted by the offeree. For the offeree, the communication of acceptance is complete when it comes to the knowledge of the offerer. So you tell me, guys, यहाँ पे knowledge कब आता है? It comes to the knowledge as on 20th April. We assume कि भाई 20th April letter of acceptance reaches, तो उसी दिन पे उसको ध्यान आया होगा. Let's assume like that. Revocation: an offer can be revoked at any time before the communication of acceptance is completed against the offerer. An acceptance may be revoked at any time before the communication of acceptance is completed against the offeree. So guys, this is the provision. On the basis of that, let's solve certain questions given in the question 3C. What it says: so on which date the offer made by Mr. B will complete? So just I have told it will complete by what time? 30th April. तो ये हमारा पहले क्वेश्चन का आंसर रहेगा. Discuss the validity of acceptance. Now, acceptance is valid or not. So guys, that depends upon which letter reaches first. Because both the letters are there. Revocation is there, acceptance is there. If acceptance comes to the knowledge by offerer first, it is valid acceptance. But if revocation comes first, then acceptance is not valid. So here we should write in both the ways. Third, it says that what would be validity of acceptance if the letter of revocation and letter of acceptance reach together. So guys, वही मैंने अभी आपको पढ़ाया कि if both of the letters are reaching together, it depends upon the fact that which letter comes to the knowledge first. So guys, the last two questions we have to write. We should have to write in by taking all the assumptions. What if this letter reaches first and that letter reaches first? Okay, fine. After that, guys, the next is about question number 4A. What are the differences between a condition and the warranty in a contract of sale? Also explain when shall a breach of condition be treated as breach of warranty under the provisions of the Sale of Goods Act 1930 for the 6 marks. Let me tell you one thing, guys. In this 6 marks, actually the ICI has asked two different questions. The first, they are demanding what? The difference. भाई पहले आप difference बता दो. And at the second hand, they have asked about that when breach of condition be treated as breach of warranty. That means we had better options available to take that opportunity as breach of condition, but still we did not consider that and we were happy with breach of warranty remedies only. So you know what is condition? We know that it is the primary stipulation essential to the main contract, and breach of the same gives the buyer the remedy to claim the price, repudiate the contract, and to claim the damages as well. But breach of warranty is not the essential, but that is collateral to the main purpose of the contract, and breach of the same doesn't give buyer to repudiate the contract, but buyer maximum can claim the damages. Okay, now what are the circumstances under which the breach of condition can be treated or considered as breach of warranty? So we know that if voluntarily or if buyer waives it off, for example, I just placed the order for Dell computer and by mistake my supplier supplies me Lenovo. I had the opportunity to cancel the contract, but instead of that what I did is I told that supplier to make it change. भाई इसको change कर दे, मुझे नहीं चाहिए. So I just waived it off. And second is, what if there is part delivery? Okay, in the part delivery we had the concept if there is a divisible contract and there is indivisible contract. If the contract is indivisible and if we have accepted the part of the goods, then later on, guys, contract doesn't become divisible. Contract is not avoidable. We have to accept the remaining goods, and if there is any defect, we cannot cancel the whole contract. We can just claim the damages. Okay, guys, so that is question number 4A. Now question 4b, again in the form of case study. Let's read that what it tries to say. तो भाई क्या कहते हैं क्वेश्चन, पढ़ते हैं उसको. M and P were partners in a firm. The firm ordered GR Limited to supply the furnitures. Okay guys, 3 partners were there and they ordered for certain furniture. P dies. Okay, that is very interesting fact. P dies and M and continues to the business in the firm's name. तो भाई एक पार्टनर की डेथ हो गई है यहाँ पे and remaining 2 are still continuing the business in the firm's name. The firm did not give any notice about P's death. Now this is very interesting fact given in the question, which can make most of the students confused. Firm has not given any public notice about P's death to anyone. You know, under certain circumstances we have to give public notices. So guys, this question will become easy for those students जिनको ये मालूम है कि on death of any partner whether public notice is compulsory or not. If we know this fact, then question becomes very easy for us. Okay, let's read further. Or the persons dealing with the firm, the furniture was delivered to the firm after P's death. Fact about his death was known to them at the time of delivery. So actually supplier knows about the fact of the death. Afterwards the firm became insolvent. Firm became insolvent means अब कुछ नहीं बचा भाई, खत्म होगी firm, and failed to pay the price of furniture to GR Limited. और पैसे नहीं दिए. So explain with reasons whether P's private estate is liable for the price of furniture purchased by the firm. So P क्या है भाई यहाँ पे? Deceased person. Deceased means what? The person who died. So whether his private estate is liable to that or not. Why? Even after death, his private estate actually goes in the hands of legal heirs. So legal heirs are not insolvent. Other 2 partners have become insolvent. So supplier of furniture, can they ask the legal heirs of Mr. P that why we supplied the furniture to that firm in which your father was a partner? Nobody is there to pay our money because all the partners have become insolvent except your father. Your father died but his asset is there. Pay the amount. तो क्या होगा? Next they are asking that whether does it make any difference if GR Limited supplied the furniture to the firm believing that all the 3 partners are alive. So basically this question focusing on the 2 major components of partnership. Actually it is on the basis of death of the partner, right? Question majorly focusing on the topic that during at the time of death of the partner, what will be the subsequent liability of deceased partner? Will he be considered as liable or not? And second focus is whether public notice is compulsory or not. These 2 points we had to explain. हमें करना है and hope आपने वो किया ही होगा. So let me tell you guys, public notice is not compulsory at the time of death. If the person is retiring and the partner was active, then the story is different. But if there is death, public notice is not required. So whether outside public who is dealing with the firm, whether they know that there are 3 partners, whether they do not know that there are how many partners, deceased partner or his private assets are not liable for any liability. Now here another argument is, but a transaction had been taken place. Understand, transaction was taken place before death. That is another fact of the question. Transaction taken place before death of the partner but completed, transaction completed after death of partner, then is he liable or not? Then he is liable or not. Understand, incomplete transaction comes under retirement. कहाँ पे आएगा भाई? Retirement में आएगा. Comes under what? Retirement. In the retirement वाला topic we had this, that if there is any incomplete transaction which got initiated before retirement but completed after retirement, whether retired partner is liable or not, then answer was yes. but understand the circumstances were different. वो retirement में था भाई, death में नहीं है. Guys, in the death law, by taking the reference of certain case studies, clearly mentioned that if there's a death, liability over. So any incomplete transactions were there in case, then legal heirs or any of deceased person's private estate is not subject to confiscation, not subject to any liability. So in this question, guys, in both the ways, the third parties, the outsiders, cannot claim the money from the private assets of the legal heir of Mr. P, who is deceased partner here. ठीक है, तो वो पैसा नहीं मिल सकता क्योंकि डेथ के बाद जो भी इनकम्प्लीट ट्रांजैक्शन है उसमें कोई लायबिलिटी नहीं रहती, सब्सिक्वेंट में तो बिल्कुल नहीं रहता, चाहे पब्लिक नोटिस दिया हो या नहीं दिया, कोई फर्क नहीं पड़ता. ओके गाइस, सो कौन सा क्वेश्चन कर रहे थे? क्वेश्चन 4 बी हो गया है. अब आगे बढ़ते भाई क्वेश्चन 5 की ओर. ठीक है, क्या कहते हैं क्वेश्चन 5? Question 5 says that Mr. T was a retailer trader of fans of various kinds. ठीक है भाई, तो there is a person who is selling the many kinds of fans. Mr. M came to his shop and asked for an exhaust fan for kitchen. हाँ, ऑक्सीजन के लिए होता है exhaust. ठीक है, Mr. T showed him different brands and Mr. M approved of a particular brand and paid for it. देखिए, यहां तक की स्टोरी आपके दिमाग में क्लियर हो जानी चाहिए, बिकॉज टिल दिस लॉट ऑफ हिंट्स आर गिवन बाय आईसीआई कि क्वेश्चन किस डायरेक्शन में जा रहा है. पहली चीज है कि हियर मिस्टर टी व्हेन एंटर्ड इनटू शॉप, द स्टोरी shows us that he is not aware about exhaust fan, कि भाई exhaust fan किसे कहता है. And that's why he says to shop owner, brother, I want such a fan which is fit for exhaust in kitchen. So basically by reading these 3 lines, what we can derive? We can derive that Mr. T totally relied upon the skills and knowledge of seller while making this purchase. He totally relied. He totally believed that whatever he provides, वो मेरे लिए सही रहेगा. Are you getting my point? So understand, guys, that whenever we make the purchase, we know that there is one implied condition. एक implied condition आती है. That when any person relies on seller, his skill, his knowledge, his judgment about the product, and he specifies his purpose, that for what purpose he needs the product, the goods, वो purpose भी बताता है, then it is an implied condition that it becomes duty of the seller to supply those goods which are best fit for his purpose. You know, we had one question as well, that one person goes to the showroom and he's asking that I want such a car which is best for the touring purpose, but by mistake the seller, supplies Bhagwati, which is actually a racing car, and later on he meets with an accident. So is there any remedy? Answer is absolutely yes. It is a breach of condition and he can claim the price by just repudiating the contract, and he can claim the damage as well. तो वही तो यहाँ पे हो रहा है. He is specifying that he wants the exhaust fan. ठीक है. So M, read further question आगे क्या कहता है? M approved of a particular brand and paid for it. Fan was delivered to Mr. M's house. At the time of opening the packet, he found that it was a table fan. जब ओपन किया तो कुछ निकला, तो उसमें पता चला कि भाई ये तो टेबल फैन है. He informed Mr. T about the delivery of the wrong fan. Mr. T refused to exchange the same. वाह. Just one small clarification, guys. Mr. M is the buyer and Mr. T seller है. यहाँ पे शायद मैंने Mr. T को यहाँ पे buyer समझ लिया गलती से, लेकिन कॉन्सेप्ट में कोई फर्क नहीं पड़ने वाला. So यहाँ पे क्या हो रहा है? Mr. T is refusing to exchange. So actually he wants to take the shelter of caveat emptor. क्या वो caveat emptor का shelter ले रहा है? Absolutely yes. What is trying to say that a seller is not liable for buyer's bad selection. Let the buyer beware. He is taking the shelter of what? Caveat emptor. तो वही तो क्वेश्चन ने पूछा है. that discuss whether Mr. T is right. Does he have right to in refusing to exchange as per this sales of goods said? What is the remedy available to Mr. M? So guys, KV Tempter no doubt says that seller is not liable for the bad selection of the buyer. But guys, there is an exception. और वो exception क्या है? That if buyer specifies the purpose, that for what purpose he wants to buy, and then he relies on the statements given by the seller, even though the goods have been selected by the buyer, chosen by the buyer, still seller will be held responsible for that. तो यहाँ पे seller मना नहीं कर सकता because he specified the purpose, he relied on the skill, judgment and knowledge of the seller. It goes under the exception, one of the exceptions to the rule of caveat emptor. Now, another, तो पहले आपको समझ में आ गया कि does Mr. T have right to refuse? Answer is no. He must have to give the proper remedy. अब remedy क्या होगी? Remedy यहाँ पे ये है guys that it is a breach of condition as to what quality and fitness. Purpose बताया but the goods delivered was not fitting with the quality and purpose what had been demanded, and that's why guys he has right to repudiate the contract if he wants. He can claim his price back. And he can claim the damages as well if anything caused just because of this wrong purposeful supply. So guys, it was a wonderful question. Question 5A. Now what question 5B says about, it says that explain the doctrine of indoor management under the Companies Act 2013. Also state the circumstances where the outsider cannot claim relief on the ground of indoor management. So basically भाई यहाँ पे दो बातें पूछी है उन्होंने for the 6 marks. First, what is indoor management? You know, indoor management is also known as, किसी को याद है? हाँ? It is also known as Tarkand rule. क्या कहते हैं उसको? Tarkand rule. And another thing what they have demanded is the exception to indoor management. So what this concept is, हम सभी जानते हैं guys कि Articles of Association of the company sometimes contains the provision that if company wants to perform certain tasks, it must have to pass certain formalities like by board resolution pass kar do, pass ordinary resolution, take this approval, that approval, take this signature, that signature. Such rules are actually mentioned in the Articles of Association. Now, what is indoor management? Sometimes company doesn't follow the rules. For example, it is given that if company wants to issue the debenture, company has to go for ordinary resolution. This is written in Articles of Association. But company forgot to pass ordinary resolution and issue the debenture. And later on when debenture holders are asking money back with interest, company denied. वो कहते भाई कैसे पैसे? We forgot to pass ordinary resolution and that's why company is not empowered. Company is not liable to pay interest. ये company की power में है ही नहीं क्योंकि resolution pass ही नहीं किया था. So understand, company is correct in its own contention कि भाई we forgot to pass ordinary resolution. हमने वो किया नहीं था, हमको मालूम ही नहीं रहा. And that's why it is not within the power of company and that's why debenture holders actually don't deserve to get the interest. ये argument गलत नहीं है. But it will be unfair treatment towards debenture holders because they believed at the time of taking the debentures कि भाई ordinary resolution pass करके आया है. So debenture holders had the knowledge that ordinary resolution needs to be passed, but they didn't inquire. Look, this word is very, very important. They did not inquire whether such a resolution is passed or not. But now company is turning around stating that sorry, we will not pay interest. So guys, just to protect outsiders from such non-compliances of such formalities, this doctrine, this principle called doctrine of indoor management has been introduced by the law experts, the law scholars. So what they have said कि भाई, if the people who are dealing with the company, they have knowledge of what is doctrine, what is the formality, it is the duty of the company to complete that formality. People who are dealing with the company always has rights to believe that whatever formalities supposed to be completed have been completed. They don't require to inquire about that कि भाई क्या वो होना था, वो हो चुका है नहीं हो चुका. They don't require to do that. This concept is known as indoor management. Whatever supposed to be done, they have right to believe कि that have been done. They don't require to investigate about this. Okay, but this rule has certain exceptions. What's that exception? Let's go one by one. Okay. Yes. So when outsider who's dealing with the company already knows that what formality needs to be completed, with that he also knows that whatever supposed to be completed has not been completed. Still he enters into contract. अब यहाँ पे you tell me now whose mistake is there? Whose mistake is there? आउटसाइडर को पता है कि भाई ये चीज करनी चाहिए थी, कंपनी ने नहीं की, लेकिन फिर भी भाई साहब क्या करते हैं, कंपनी के साथ कॉन्ट्रैक्ट में जाते हैं. तो यहाँ पे गलती किसकी है? यहाँ पे गलती बाहर वाले की. जब आपको पता है कि ये नहीं किया तो क्यों आप कॉन्ट्रैक्ट में जा रहे हो? इन दैट केस यू विल नॉट बी गिवन द रिलीफ अंडर द डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट एंड कंपनी विल विन. सेकंड गाइस, ये मैंने एक समझाया, बाकी आप सब जानते हैं, हमने क्लास में डिटेल में पढ़ा है दैट नो नॉलेज ऑफ आर्टिकल्स, अगर फोर्जरी है, नेग्लिजेंस किया है, अगर अल्ट्रा वायरस एक्ट से, रियली अल्ट्रा वायरस एक्ट है, not even by any formality, company doesn't have power at all, and that kind of thing is done. For example, company has the power to finance only 100 crore rupees and by mistake the company entered into contract to finance 150 crores. ये तो उसके पावर में नहीं है, चाहे आप कितनी भी फॉर्मेलिटी खत्म कर दो. So for those formalities, for those beyond the powers, ultra virus acts, company can't be held liable under indoor management. Okay guys, so ये भी काफी beautiful point था यहाँ पर. हमारा question 5B for how many marks? 6 marks. ठीक है, for the 6 marks. Hope आपने अच्छी तरीके से उसको लिखा होगा. Okay, now next is the question 6A. Again guys, as we can see that here question number 6A and question 6B, these two are the straightforward questions. Directly they asking, the first it says that the general rule is that an agreement without consideration is void. Without consideration is void. Discuss the cases where the agreement though made without consideration will be valid and enforceable as per the Indian Contract Act 1872. So guys, this is the exceptions to those rules. No consideration or no contract. So what are those exceptions? हमने ये जरूर पढ़ा होगा that according to section 25 subsection 1, if a contract has been made by following the conditions for the natural love and affection, even though there is no consideration is existing, but still the contract will be considered as valid. Section 25 subsection 2, it says about the past voluntary service, those services which had already been served, consideration had not been promised, but now it is promised that yes you will get the amount, then yes, even though it was not promised, but फिर भी आपको मिलेगा. Then 25 subsection 3, it says promise to pay time bad debt. So guys, time bad debt, actually those debt on which you have not initiated any legal actions to recover the amount, and that time what is given in the law of limitation is expired, and again you are promising in writing that हाँ भाई वो पैसा जो उस साल मैंने पे नहीं किया अब दूंगा. Then guys, even though for this new arrangement, even though there is no any consideration, it is a valid agreement. And then completed gift. What is completed gift? We already know. Gift, what is already given. Donation which is already given, even though there was no any consideration, हम उसको वापस नहीं ले सकते. And contract of agency. Contract of agency guys, just like a partnership. Partnership में कोई consideration fix नहीं होता. There may be consideration, there may not be, but still partnership is a valid contract. तो ये सारे exceptions हमको वहाँ पे लिखने थे. After that, discuss the liability of a partner for the act of the firm and liability of the firm for act of a partner to third parties as per Indian Partnership Act 1932. ये भी काफी easy question है. So basically हम ये जानते हैं guys कि if partner is authorized and if he is doing his act within the authority, then action of partner binds the firm and all the partners of the firm are liable for that liability. आप समझ रहे हो? ठीक है. After that, if a partner makes the fraud with the third party, whether firm is liable or not. So again guys, the point is, even though it's a fraud, but if it is made within the authority, then yes, firm is liable. Later on, the firm can definitely recover the losses from that concerned partner. That's a different story. Lekin yes, firm will be liable for the third party. Example में हमने ऐसा समझा था that if one partner is actually authorized to collect the payments from the debtor. So one debtor paid him 10 crore rupees and he did not account to the firm but directly took and just flew foreign country. जब बाद में फर्म को पता चला, can firm recover amount again from that customer? Because customer when pays to the partner, that means he has paid to whom? To whom? Firm. Provided वो authorized होना चाहिए. ठीक है? तो guys ये था हमारा question 6B. Okay. After that question 6C. भाई ये क्या कहना चाहता है? That SK Infrastructure Limited has a paid up share capital divided into 6 lakh equity shares. तो भाई यहाँ पे ध्यान रखिए, ये काफी इंपॉर्टेंट डेटा दिया है यहाँ पे. इसका पूरा बाइफर्केशन हमें लिखना था. टोटल इक्विटी शेयर्स दिए हैं 6 लाख. ओके आगे बढ़ते हैं. क्या लिखा? Of INR 100 each, 2 lakh equity shares of the company are held by central government. अरे वाह क्या बात है. So out of the 6 lakhs, when we focus to the data, 2 lakhs held by whom? Held by central government. Okay. And 1,20,000 equity shares are held by government of Maharashtra. अरे वाह 1,20,000 है ना? हाँ 1,20,000. Yes. 1,20,000 by state of Maharashtra. So basically they want to give you the hint कि भाई ये state government है. ठीक है. और आगे बढ़ते हैं. Explain with reference to relevant provisions of the Companies Act 2013 whether SK Infrastructure Limited can be treated as government company or not. तो भाई यहाँ पे section 245 of Companies Act का question पूछा है. Section 245 discusses about what? The definition of government company. वो क्या कहती है? सिंपल सी बात है कि if at least 51% of the total paid up share capital if either held by central government alone or state government alone or state government plus one or more state government, central government or one or more state government, then that particular company will be considered as government company. So we have to analyze over here that total of these two goes beyond 51% or not. So अगर हम दोनों का sum करेंगे, why it comes to what? 3,20,000. So 3,20,000 अगर हम बात करेंगे यहाँ पे, आप कैलसी यूज कर सकते थे यहाँ पे, right? So let's do that. 3,20,000 divided by कितना है? 6 lakh multiply by 100. So guys ये total percentage what's given here, it comes to 53.33%, which is actually more than at least 51%, and that's why guys answer would be absolutely yes. SK Infrastructure Limited will be considered as the government company, and all the provisions of the government company in the Companies Act 2013 will apply to this company as well. ठीक है? So guys ये था हमारा बिजनेस लॉ का पेपर. होप काफी इजी पेपर था, थोड़ा लेंथी जरूर था, लेकिन काफी अच्छे और स्ट्रेट फॉरवर्ड क्वेश्चंस कुछ ज्यादा पूछे थे. नवंबर 20 के कंपेयर में अगर हम इसको कहे तो यस ये कंपैरेटिवली इजी था. वहां का पेपर काफी लेंथी था, बच्चों को थोड़ी परेशानियां भी हुई थी, लेकिन ये पेपर अगर हम कंपेयर करें तो काफी इसी तरीके से हम उसको टैकल कर सकते थे. तो आई होप गाइस आप सभी ने काफी अच्छी तरीके से लिखा होगा. तो अभी और नए पेपर के लिए आप प्रिपेयर कीजिए. अभी जो हो चुका ये मत सोचिए कि भाई क्या लिखा था, ये मेरा आंसर गलत हो गया, वो आंसर मेरा गलत चला गया. जो हो गया. अब आराम से अपने नए पेपर के लिए आप प्रिपेयर करिए. ठीक है? ऑल द बेस्ट.